YouTube, LinkedIn, Twitter, and TikTok. Hello, everyone. How are you doing? It's already 4 p.m. on this side of the world. Thank you, Abna Sugar Trust. You're so kind. I really appreciate it. How's everyone doing? It's been a busy day full of meetings, but today I'm coming your way where we're just going to chat about how to get a 10-year green card without an interview, how to get a 10-year green card without an interview. So that's what we're going to be discussing today. TikTok, let me feel your magic. If you guys are live, drop me an emoji, the flag of the country where you're connecting from. Drop us the flag of the country where you are currently located as we dive into this live video. Okay, so I'm going to be sharing my screen with Facebook, LinkedIn, YouTube, and Twitter. And we're going to be looking at what the requirements are to get a 10-year green card without an interview. I see your emojis coming in. I see your flags. Good job, guys. Okay, now let me go. Oh my gosh, my screen is looking so small. The writing is so small. Let me see if I can open this up. Okay. So you guys know that, the immigration, well, US immigration is always a journey. It's always a journey. It's never like, you just apply today and then within a few months you become a US citizen. That's normally not the case. A lot of immigrants have to go through the journey. So a lot of people would sometimes start from the visa process and then they'll, move on to the green card process, the green card stage, and then after the green card, you move on to citizenship. So you can normally not graduate to become a US citizen if you don't have a green card. Okay, so normally the green card is the starting point for trying to live in the US. Okay, so when you get, well, as you guys may know, again, one of the most common ways of getting a green card is through marriage to either a US citizen or a green card holder. Now, if your green card was obtained through marriage, if your marriage is less than 2 years on the date of the approval of the green card, or on the date you are granted your permanent residence, you're going to be given your conditional green card, which is a 2-year green card. Guys, remember that the conditional green card, which is a 2-year green card, as well as the 10-year green card, which is a permanent green card, they both have the same features. They are both, they both have the same type of power, so to speak. The only difference is the validity, right? The conditional green card is valid for only 2 years. The permanent green card is valid for 10 years. Now, here's how you can get a 10-year green card without a waiver. We're going to go through 4 eligibility criteria, right? Again, whether or not to invite you for an interview is normally up to the discretion of the immigration officer who will be reviewing or adjudicating your case. Okay, so now let's take a look at the 4, what are the 4 things an officer will be looking at or will be reviewing in order to determine that, okay, we're not going to invite this person for an interview, we're just going to approve their green card, give them a 10-year green card. Okay, and guys, remember also that if your marriage is, let's say even like less than a year, so far as it's a bona fide marriage and you are trying to remove the conditions, there's no timeline for filing to remove the conditions. Okay, this should be juxtaposed or differentiated from a marriage which is, you're still together with your partner and you intend to remove the conditions on your marriage jointly. If you do intend to remove the conditions jointly, then you need to apply 90 days before the expiration of your 2-year green card. But if you are going to remove the conditions on your green card, on your conditional green card, that's on your 2-year green card, based on a waiver, then there's no timeline. Okay, so any time goes. Now, here are the 4 criteria. The first thing we're going to be looking at is, okay, so USCIS does waive interviews. That's the first thing to note. USCIS waives interviews. If your case is very well prepared, they could waive the interview. They could spare you from coming to an interview. Okay. Now, the first ground is that number one, there must be, so we're talking specifically about removal of conditions, waiving the removal of conditions interview. So this presupposes that there has already been a first round of interview. Guys, remember that if you apply for a green card, there's normally a first interview, and then you have a second interview, which is the removal of conditions interview. Now, the first interview will be done. It's the second interview we're talking about it getting waived. Okay, so waiving interviews. First of all, you have to show through your application that you have sufficient evidence of the bona fide of the bona fides of the marriage. This, bona fides of the marriage, you just have to show that the marriage is real. You entered into the marriage not to evade U.S. immigration laws, but to establish life together with your partner. You need to establish that by a preponderance of the evidence. If you actually have demonstrated solid bona fides, or your bona fides are sufficient, then they can waive your interview. Again, please note that when we talk about sufficiency of the evidence, you need to make sure that you are sustaining your burden of proof by the required legal standard. And the legal standard for a marriage-based case would be by the preponderance of the evidence, which means that there's a 50%, chance that the marriage is a real marriage. It wasn't a marriage where people paid money. Okay, so you demonstrate by sufficient evidence that the marriage is bona fide. That's the first thing. Sufficient evidence is the key word. And how sufficient, guys? If you are cooking food, right, and somebody's, is the food sufficiently salted? Okay, it is very different from someone else's definition of whether food is sufficiently salted. If food is sufficiently peppered, it's subjective. Somebody likes a lot of pepper, hot, hot, hot. Someone doesn't like too much pepper. When it comes to U.S. immigration law, legal standards, it cuts across, each case type has its own legal standard. When we're talking about a marriage-based green card, the legal standard is by a preponderance of the evidence. So that phrase, sufficient evidence, has to correspond with the type of legal standard for your case. And in this case, it will be by the preponderance of the evidence. So please note there has to be sufficient evidence, and sufficiency, whether the evidence is sufficient or not, is really, it's a matter of having a legal eye to be able to determine that, okay, this is sufficient or this is insufficient according to law. So it's not something you feel like, okay, I've added 100 pages of something, and so that's sufficient evidence. It's not really about the quantity. It's a combination of the quantity as well as the quality of the evidence. And when you are producing evidence for your green card case, remember that the evidence has to be probative, it has to be relevant, and it has to be credible. So all these things are things you have to meet in order to satisfy that ground that there's sufficient evidence of the bona fides of the marriage. The second thing is that the principal petitioner must have been previously interviewed. Okay, the principal petitioner in an I-751 is normally who is known as the beneficiary in an I-130. The principal petitioner in an I-751 is the principal applicant in an I-485. Okay, the adjustments of status. So pretty much the I-751 principal petitioner is the foreign national. Okay, that's the foreign national. That's the person who bears the green card, not the husband or the wife who, kind of filed the application for them. So they should have been interviewed. So an officer should have already met them in person. They should have felt their vibe, seen their eyes, read their body language in order to be able to grant this interview waiver during the removal of conditions process. Now, the third thing they are going to be looking out for is this: there must be no indication of fraud or misrepresentation in the I-751 or supporting documents. So if there's any indication of fraud, then you're not going to get a waived interview. They're going to call you for an interview and then, make sure that they clarify what they need to clarify. So on the surface of it, and even when they go into your document, there mustn't be any indication, like there shouldn't be anything that looks fishy or suspicious, okay? That will cause them to question whether there's a misstatement of fact, or there is pretty much a misrepresentation of something. Misrepresenting something means you're stating it um, and the true facts are not reflective of what you are stating, okay? Now, the fourth thing, all these eligibility criteria have to be satisfied. It's not an alternative. All these things, the fourth thing you have to satisfy is that there are no complex facts or issues requiring an interview. If there are complex facts or issues requiring an interview, then they're not going to waive your interview. They're going to call you for an interview so that you can clarify those facts or issues. Okay. So that again is a matter of fact. Like, what is a complex fact? So for example, if an officer picks up your application and then they felt like, okay, well, in order to file a marriage-based green card, for example, the marriage should have been consummated. What does consummated mean? It means that the couple should have had sex. If the couple has not had sex, then the marriage is not valid. According to U.S. immigration law, the marriage should have been consummated. And you know what, guys? Even the timing of the consummation is relevant for U.S. immigration law purposes. The consummation or the sex should not have, whether you guys had sex before the marriage doesn't count for the purposes of consummating a marriage or for the purposes of a valid marriage. Consummation should have happened after the fact, right? After the marriage. So if, for example, the officer sees your application and feels like, I'm not clear, I don't believe you guys consummated the marriage, and he wants clarification. Or sometimes what will happen is that some people will get married, virtually, and then they will meet later to consummate the marriage. The Foreign Affairs Manual states that consummation of marriage, if it's done after the marriage, is still valid for the purposes of U.S. immigration law. Because you know why? When you are submitting a U.S. immigration law application, you should be eligible at the time you are actually submitting it or applying or filing your application. So if the marriage has not been consummated at the time you are, immediately after the marriage, let's say you did a virtual marriage where they do Zoom weddings, right? So you did a Zoom wedding. Once you've done a Zoom wedding, your marriage is not valid for U.S. immigration law purposes because the marriage has not been consummated. You have not had sex. You've not held your husband. He hasn't held you. Now, if you meet 3 months later or 2 months later and you have sex, you've consummated the marriage. And now that consummation or sex goes back to validate the marriage. Now, if the officer says that, okay, what happened at the time you submitted, it wasn't a valid application or whatever, it could be a complex fact to him. So he could call you guys for an interview just so that you guys can explain what it is. Something like this is a matter of law. So you need to make sure you have an attorney to explain these things to the officer. But if there are no complex facts, then they can go ahead and approve you without an interview. So number one, sufficient proof of the bona fides of your marriage. Number two, there's no the principal petitioner was previously interviewed. Number three, there's no indication of fraud or misrepresentation. And number four, there are no complex facts or issues requiring an interview. If all these factors are present, then it's possible that your green card application, the removal of conditions application, you could be approved without an interview. You could be approved for a 10-year green card without an interview. So we shared results. We recently got a client. They even divorced. Our client was a Ghanaian, and he got divorced from his wife. And we got the approval in 5 months. He got the 10-year green card without any interview. And people were screaming, how is this possible? Is this possible? Yes, it's possible. Those are the steps I've just taken you through, right? So if you need help, just call us 802-7800-564. We have a lot of questions. Let me answer a few questions. I have Jonathan Donas on TikTok. He's saying, our application is marriage approved and have been sent to Ghana, but since May, they've not called us. It's been sent to Ghana. Have you been documentally qualified? Which dates were you documentally qualified? And then I can tell you, or is it at NVC? Okay, I said they're saying that there's a lot of backlog because of COVID. Absolutely true. They're currently 2 years backlogged. They're currently 2 years backlogged in Ghana, the US Embassy in Ghana. So, for example, they're currently working on people who are documentally qualified, immigrants visas, October 2020. So you still have a long way to go if you were just recently documentally qualified. BB Boatema. Hello, baby girl. Thank you for joining, Esquire. So Adigan on Instagram says, I would love to ask if an immigrant visa was sent to NVC, how long does it take to let the embassy call for interview? So that's what I was just explaining. Which, number one, who's the petitioner? What's the immigration status of the petitioner? What's their relationship to you? Are they green card holders? Are they US citizens? What's their relationship? Is it a parental relationship, child, sibling? Is a child married above 21? All those will factor. And then your question again is how long, if it was sent to NVC, how long does the embassy? Okay, so if your application was sent to the NVC acts as a liaison between the United States Citizenship and Immigration Services and the US Embassy based in your home country. So NVC will tell you, Adigun, bring your, fill out your DS-260, go for your police records, go for your medical records, submit all the supporting documents. If you are able to do, submit your affidavit of support. If you're able to do that properly, they will review it and then they will, either reject or approve sort of your application. If everything is, submitted and it goes through, then you'll be sent an email to show that you're documentally qualified by a certain date. And that's the date that will show how long it will take. In Nigeria, based on what consulate, is it Lagos or Abuja? Then we are able to see what the backlog is. So there's just too many permutations to be able to give you a timeline. Also, what was your priority dates? That's also kind of instructive, but normally when you are documentally qualified, and then the embassy your beneficiary is based in. Okay. All right, guys, it's already 4:30 p.m. I have to go now. Feline's Glams where it says, please, can I fill DV application via phone? Sure, try it. Let's see if it's gonna work, but I would try by computer. Ama Akua, hello, hi guys, hi everyone. Kwame De Ghana says, please, can your case at the U.S.A be expedited? Yes, if you have an urgent, or an emergency humanitarian reason, such as illness, death, like anything crazy where they feel like, oh, there is a need for them to adjudicate your petition ahead of everyone else's. You guys know that Americans, let me take the screen off. You guys know that Americans want people to respect queues, right? Like if you go to Starbucks, McDonald's, like Chick-fil-A, whatever, everybody's in line. Walmart, everybody's in line. You cannot cut across someone, no matter how trivial, even if you're getting like Dunkin' Donuts, like, or maybe one bar of chocolate. They want you to be in line. It's the same with U.S. immigration law. People are ahead in line, and your priority date tells you your place in queue in the U.S. immigration line. Now, if you want your case to be expedited, you want to cut across people who have been waiting for 2 years just to join their spouses, then you have to have a good reason. So if it's based on an urgent humanitarian need, you have to support that request with credible evidence that will demonstrate the need for your case to be expedited. Okay, so I'm getting requests to join the live. Guys, today is not a good day. We're going to do a session where I'll invite a couple of you to join in the live. I'll have a moderator. You guys can submit your questions before, and then we can have you on the live feed. All right. So I have to hop off. I wish you guys a wonderful rest of your evening and a great day. Take care. Bye, Instagram. Oh my gosh, I can't believe I didn't read any comments on Facebook. And Aaron Abebio on YouTube. Okay, he dropped the Ghana flag. And then we have Kate Chinyere says, how can we ask questions as you proceed on Facebook? Drop your questions. We can answer them in our next feed. Juliet Soku says, you're doing a great job on Facebook. Thank you so much. Juliet is on Facebook. Now, TikTokers are also here, guys. We ended the live video for Instagrammers, so we have to end it for all of you to thank you all for joining. So hopefully I'll see you guys. Oh, guys, tomorrow I'm doing a live video with SVTV where I'm most likely going to share the poster. So please join us on the live video. We're going to be chatting about the visa lottery and other US immigration law topics. Okay, take care. Have a good evening. Bye. Bye, TikTok.